To make you the smartest person in the room, we need to connect up the critical dots between the indictment of those individuals associated with the National Basketball Association in terms of an alleged illegal gambling ring, illegal poker ring, and the like, and how that connects up to your right to keep and bear arms. You may ask, Mark, how does this all connect up and how does this help us? The answer is this all helps us very, very much. You'll see why when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxer Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, so just want to remind you all, this Thursday I'll be giving a major presentation at the National Lawyers Convention for the Federalist Society. So that should be available with a live stream on Thursday at 2 p.m. where I'll be speaking to a whole room full of law clerks, lawyers, judges, scholars, influencers, all that stuff. I am told there's thousands and thousands of people that will be at the convention this year that is fully sold out, and a whole list of prominent federal judges, many of whom we've talked about on this channel, will all be there. So an exciting time. I haven't looked at the entire list and the whole schedule of the convention. I probably need to do that, but I can tell you that I will be speaking 2 o'clock on Thursday Eastern Time in Washington, D.C. All right, with that said, I need to connect some dots for you. This is extremely important and very good news. As you may have seen, Kash Patel of the FBI, along with Pam Bondi and the Department of Justice, on the first day of the season, of the NBA season, opening day, it was announced the indictment of many, many people associated with a alleged illegal gambling operation, some of which apparently involved sports gambling, some of which apparently involved poker rooms and like. Anyway, several people associated or affiliated with the National Basketball Association in one way or another were somehow connected with this, and some of them were even indicted on criminal charges in the United States, District Court for the Eastern District of New York, which is in Brooklyn, New York, by the way. They were indicted by the Bondi Department of Justice. Now, I want to tell you what Kash Patel had to say about this indictment, and then I'm going to explain to you why this is very good news for Second Amendment rights. I know it's not obvious to most people, but I'm going to connect the dots to make you the smartest person in the room, and I'm likely the only person that has connected these dots, so you will have access to that in about 2 minutes. But to begin with, here's what Kash Patel, the head of the FBI, had to say about these indictments just a couple days ago. Today, the FBI arrested 6 people, including current and former NBA players, for their alleged role in illegal sports betting and money laundering conspiracy. The result of a sweeping investigation conducted by outstanding FBI professionals and partners. Using private information positions of power to rig sports gambling outcomes is not only illegal, but destroys the integrity of the game and will never be tolerated. We will continue following the money to ensure gambling operations of all kinds stay within the law and bring to justice those who take advantage of innocent victims. This is from FBI Director Kash Patel. All right, so how does this help us with the Second Amendment? And the answer is this actually helps us in a very big way with a critical question that keeps coming up in this fight we have over what constitutes a dangerous individual who's been convicted of a crime that's dangerous versus a non-violent or a non-dangerous individual that has been convicted of a crime. How do we draw these distinctions? And this case actually helps us draw a critical distinction that you all need to understand between what is a dangerous criminal who's been convicted of a dangerous activity on the one hand versus an individual that has been convicted of a non-dangerous, non-violent crime on the other hand. So to begin with, before we explain the connection here, I want to remind you that the critical distinction that is being pushed by Second Amendment advocates and Second Amendment lawyers and Second Amendment scholars, which I support, between what constitutes an individual who can be disarmed by virtue of the crime they were convicted of, versus an individual who still can be who still can be armed, who is not allowed to be disarmed by virtue of committing other crimes. How do we draw that distinction? Well, as a general matter, based on the U.S. Supreme Court decision in Rahimi, as you know, if you've been found by a court after a due process hearing, there's been a finding that you are a physically violent danger to others, you can be temporarily disarmed. You can be temporarily disarmed. Okay? That is a consistent theme or consistent rule of law with what was essentially found by the United States Court of Appeals for the Third Circuit there in New Jersey, Pennsylvania, Delaware. That's what the Third Circuit covers, those states. In the Bryan Range case from about a year ago, you may remember the Bryan Range case. There was a Third Circuit en banc decision that said that Bryan Range, who had been convicted like 25 or 30 years ago of a food stamp-related welfare crime, allegedly, supposedly he'd been convicted of this, sort of fuzzy how this all went down, but he was convicted of some food stamp-related crime under Pennsylvania law like decades ago. And because, legally speaking, he theoretically could have gone to prison for many years, even though he never spent a day in prison, by the way. He never was sentenced to a day in jail. He, in theory, because of what he pled guilty to, could have been sentenced for many years in prison. And as a consequence, that was technically considered a felony for the purposes of federal gun control law 18 U.S.C. 922 G1, which is the felon in possession law. Now, the Third Circuit said that Bryan Range was a nonviolent felon. He was not convicted or found to have been engaged or found to have been a physically violent danger to himself or to others, or anyone for that matter. So he fell on the line of nonviolent felon, which means he could never be disarmed, or at least based on those crimes. And that is in contrast to, let's say, those people who've been convicted of malum in se crimes. We've talked about the distinction between malum in se and malum prohibitum crimes before. A malum in se crime is something that is inherently immoral, even in a state of nature. Even if you lived in a world where there's no positive law, there was no Congress, no legislature, malum in se crimes are evil in and of themselves, and they will be recognized as such even in a state of nature where you had no civilization. Crimes such as rape, murder, robbery, assault, arson are examples of malum in se crimes. That is different than malum prohibitum crimes that are basically just crimes because the legislature says they're crimes. They're crimes because they have been prohibited by law and nothing else. There's no moral component. There's no just component or anything like that. Classic examples would be jaywalking, loitering, carrying a handgun without a permit, having a gun that has the wrong length of barrel. All these would be examples of malum prohibitum crimes, in contrast to the malum in se crimes. So the question becomes, for the purpose of the Second Amendment, we know that you can be disarmed at least temporarily if you've been convicted or found to be a physically violent danger to others, and by extension, likely a physically violent danger to yourself as well. You can be disarmed. But in terms of the crime, if you are so the question then becomes, though, if we assume, and it's true, and I think this is the law, clearly so, if you're physically violent danger to someone else, or you've been convicted of a crime that is a physically violent, dangerous crime, you've been convicted of rape, robbery, murder, assault, arson, that is, I think, a uncontroversial position to say if people have been convicted of those crimes, they can be disarmed, consistent with the Second Amendment for at least some period of time. In contrast, if you're purely a nonviolent felon, you've been convicted of some crime that has no physical violent nature, again, loitering, jaywalking, having a gun with a permit, things like this, without a permit, crimes like this, not dangerous. There's nothing inherently dangerous about those activities. There's nothing inherently intrinsic in the finding that you committed these crimes that would suggest that you're a physically violent danger to yourself or to anyone else for that matter. So you have these sort of two buckets of crimes: the violent crimes, the nonviolent crimes. But there's a critical, and this is where we're going to tie this in to make you the smartest person in the room, okay? There's a critical third bucket out there where there's tension and there's pushback by judges. And that is, hey, counsel, interesting theory you've got there. But how do you deal with drug dealers? How do you deal with drug dealers? Because we know the U.S. Supreme Court, as currently constituted, does not like drug dealers. They don't like drug people. They simply do not. That's why I do not love the fact they granted cert in that pot case involving the Second Amendment, but that's the subject of other videos. This Supreme Court does not like drug dealers. They don't like the drug world at all. We know that. But is there anything, and this is where the rubber is going to hit the road, folks. Here we go. But is drug dealing as a crime, it is a crime, we know it's a crime. Is drug dealing a malum in se crime, or is it a malum prohibitum crime? Is it per se a violent, dangerous crime, a physical, violent, dangerous crime on the one hand, or is drug dealing a non-violent crime? I mean, you're selling drugs, presumably to someone that voluntarily wants to buy the drugs. Hey, you want drugs? Here's some drugs. You want to pay me the money? Great, give me the money. We have a transaction here. Nothing violent about that. Or is there? And this is where I think this indictment involving this illegal gambling operation solves the problem in our favor. And what do I mean by that? The right answer, by the way, and I say the right answer not in some theoretical sense, but in what's going to be the answer by this U.S. Supreme Court on this question is this. Yes, if you deal in drugs illegally, that will be considered a violent crime, and it will fall on the line that you can be disarmed, at least temporarily. And this NBA indictment case explains why that's the case. Why is that the case? You see, if you sell in the black market, if you sell drugs or engage in black market transactions, that is inherently violent, physically violent. And why is that? Because the only way you can enforce your contracts is through violence or the threat of violence, because you're not in a position to be able to take your dispute with the other party to the transaction, with your counterparty. You're not going to be able to take any disputes involving that transaction to court because you're both engaged in something that is criminal. It is illegal, which means you're going to have to you're going to have to resort to self-help to enforce your contracts. And that is where it becomes violent, because the only way a drug dealer can enforce his contracts or collect on his debts with the people he provides illegal drugs to is through violence or the threat of violence. If you don't pay me your debt for the heroin I sold you, I'm going to break your kneecap. Now, the reason why this ties into this NBA case is that is a big part of this particular case. You see on page 38 of the criminal indictment in this NBA illegal gambling allegation, this indictment, they specifically point out that the way these gambling contracts, any gambling debts were enforced was through violence or the threat of violence. Here's what paragraph 38 of the indictment has to say about this. With respect to poker games held in the New York City area, members and associates of the Bonanno, Gambino, and Genevieve crime families use threats, listen carefully folks, use threats and intimidation to assure payment of debts from the rigged games and the square illegal poker games organized by the various defendants and their co-conspirators, as well as to protect the games from competition and other potential threats. You hear what I just said? Paragraph 38 of the criminal indictment, they literally say that the way the gambling debts were enforced, and keep in mind that the poker games, in addition to being illegal, they were scams apparently. In other words, you would go play poker there illegally, but the problem was that they had set it up where they knew what your hole cards were, and they did other ways of cheating you. So the people that showed up were getting cheated at the poker games, and when they complained about this, the crime families would step up and threaten them with violence or use violence to make sure the debts were paid, the gambling was paid, the bills were paid, even though they'd been scammed. And again, goes back to my point that the problem with organized crime, the problem with drug dealing and why it is a physically violent activity that's going to fall on the physically violent, dangerous side of the equation, more analogous to the Malum and say rape, robbery, murder, assault category, as opposed to like having a gun that has too short of a barrel, or loitering or jaywalking, which is malum prohibitum. The reason why the drug dealing or organized crime stuff is going to fall on the physically violent, dangerous side of the line is because the way the agreements are being enforced or are enforced in the black market is by virtue of the fact of violence or threats of physical violence. And this, by the way, in addition to being in this particular case involving the NBA players and the NBA Association, it also comes up repeatedly all over the United States with the DOJ. In fact, a quick review shows that there's countless examples of people being convicted and sentenced over using violence over drug debts, to repay drug deals. People have been kidnapped, and their children have been kidnapped to make sure that people pay off the debts. This is how you enforce drug debt collection all across. There's a story in Pennsylvania where a 14-year-old child was kidnapped over a $500 cocaine debt by drug dealers. We know that the cartels engage in all sorts of torture and other misdeeds, kidnapping, all to make sure that various illicit debts get paid. So in light of all this, the summarize is following. When you're discussing and laying out for people what constitutes violent versus nonviolent, physically violent versus not physically violent, make sure you place drug dealers and organized crime activity on the side of the aisle where that is a physically violent, dangerous crime. If you're convicted of those things, you can be disarmed, consistent with the Second Amendment, because that is a big question that often gets asked by judges in these nonviolent felon cases. Well, based on your theory, how do you deal with drug dealing? How do you deal with organized crimes? Aren't these really not violent by their nature? And the answer is they are physically violent, dangerous activities, because the way the agreements are enforced by the pimps, by the drug dealers, by the people handling the illegal gambling operations. The way they enforce their crimes is not by going to court. It's by threats of violence and actual violence. And as a consequence, if these people are convicted of doing these activities, they are indeed convicted of a physically violent, physically dangerous activity, which places them on the side of the aisle where they can be disarmed, at least temporarily, by virtue of the conviction of those particular crimes. And it's important to understand this to make sure you understand comprehensively how to deal with the nonviolent felon versus violent felon in terms of what a person is convicted of. All right, folks, there you have it. Hope you enjoyed today's episode. Make sure you follow me over there on X at @4boxdiner. Don't forget to subscribe to YouTube and to Rumble, and I look forward to talking again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.